Good morning, class. Good morning,
Good
class.
morning, sir.
Good
Good morning, sir.
Good morning, sir.
So I'd like to welcome you to this morning's class. I don't know why many of you are yet to join, even despite the fact that.
Good morning, sir.
So I'd like to welcome you to this. All right, so I think we've waited enough. So it's good that we proceed having fulfilled all righteousness. Now, last class, we started looking at the classification of law, and then we began, first of all, by examining the functions of law in a society, and then we looked at aspects of law, stroke classification, and under the aspect of law, we were able to look at about 5 different aspects, which that we mentioned natural law as an aspect of law, even though some also classify natural law as a class of its own. But for the purpose of the lecture, we did establish that we will refer to it as aspects of law. Also, we looked at divine law, eternal law, and the positive law. And I recall that I did mention that in today's class, we will then look at the major classification of law. And this will take us some time to juxtapose the different classes that we have together in order for us to be able to establish some form of understanding on the topic. So we examine the major classes of law in this particular class. And then also, by way of reminder, I would like to say that law can be classified into different categories based on their shared features. And what governs this classification is usually based on the feature of this particular law, particular class in question. And it's the classification only helps us to know the various features of law and the relationship between the different categories or the different classes of law that we have. Because in this class, you will see how we were able to put a particular class of law side by side with another class, with the main purpose of trying to detect the major features, the distinguishing features among them, and to help us to simplify the understanding of the study of law. Many people will be confused when it comes to these various classifications we're talking about. But all you need to know, first of all, is that the decision to classify law into these classes is to enhance understanding of law students, and also even those that are non-lawyers that intend to understand law in detail. So we will look at these major classes, and they have their unique features. That's one thing we need to note, that these classes have their unique features. Notwithstanding the unique features, they also have area of overlap with other classes that we may consider. For example, we will look at common law and civil law. We will see in the course of examining that there are some aspects of common law as a class of law that overlaps with civil law, and so on and so forth. So basically, the class or the topic is to give us the opportunity to be able to understand the different types of law with their unique features. So therefore, we are going to start with number one, which is the common law and civil law. We have paired these two together, and then we will look at the two of them together, look at the where the unique features and the area that they overlap. So the first class we are going to look at is the common law and civil law. I want to believe you can hear me. Please kindly just signify.
Yes, sir.
Okay. All right, that's fine. Thank you for the confirmation. Okay. So the first one we are going to look at under this heading of common law and civil law is the common law. Now, the term common law as a class of law is not new. But for the purpose of this class, we are going to take it as if it's new altogether. So common law, by way of definition or by way of explanation, are rules based on the immemorial custom of the English people, and they are enforced by the whole common law courts of England. Common law are rules based on immemorial custom of the English people, enforced by the old common law courts of England. Now, you may be hearing the term custom. This will, in a way, make you understand that every nation or every people, so to speak, or community have their unique customs and laws. So it is some form of misunderstanding to think that one person's culture is superior to another. But we need to know that irrespective of how civilized a particular nation may be, they have their own custom. And in the case of this particular aspect of law or class of law that we're looking at, when we talk about common law, we simply refer to rules and regulations that are based on the custom of the English people. And they are rules that grow or that grew from the custom that is common to the people of England and Wales. Custom that are just like when you look at Nigeria as a country, there are cultures in the Yoruba land that are similar to that of the Igbo people. There are cultures, there are aspects of the Igbo culture that we also see in some other group or other cultures. But if the Nigerian state can harmonize all of this law, it will be easy for us to call it our own customary law. So this was the case with the English people. They looked at the customs that are common to the English people in Wales and England, and then they put them together and they call them common law. So common law as a class of law originated in the early Middle Ages in the King's Court. Now, one of the things this particular class will teach us is the history of these classes of law that we are going to be looking at. So, in the case of common law, it had its origin in the early Middle Ages in the King's Court, popularly known as the Curia Regis. Curia Regis is a Latin word. Curia will spelled C-U-R-I-A, and Regis is R-E-G-I-S. So, common law originated from this time in the King's Court. So, common law is part of the English law that is derived from custom and judicial precedent of, rather than laws enacted in statutes, or rather than laws enacted by the body saddled with the responsibility to make laws. So that is common law for us. It is derived from custom and judicial precedent or decision, which, of course, when we look at indigenous law here in Nigeria as a people, one of the major distinguishing factors between our legal system and that of other legal systems is that we have a system of precedents, which is also known as the doctrine of stare decisis. So this that aspect of our system was drawn from the English people. Okay, so common law, like we said, there are rules based on the immemorial custom of the English people. And then the doctrine of judicial precedent or stare decisis is another name that that often springs up when we are talking about common law. Okay? Now, the doctrine of judicial precedent is that which postulates that decision of superior courts are binding and must be followed by inferior court in appropriate cases, in appropriate cases or situation. So simply put, the doctrine of stare decisis or judicial precedent is that which emphasizes the need to apply a particular decision that may have been reached by a superior court to a similar matter at the lower court, especially if the facts of the case or the cases are the same. Then the court, the lower court or the inferior court, is duty bound to apply the position of the law as held or determined by the superior court. So, and when a decision is reached by the higher court, the doctrine makes it binding on lower courts only in appropriate cases, not in all cases. So that's one of the major features of the common law system. And when we talk about judicial precedent, it has its origin in the common law of England. Furthermore, common law was developed by the King's Bench. That is, the King's Bench, the Court of Common Pleas, and the Court of Exchequer. All of these are the courts that forms the King's Courts. Okay? These are, the various courts that forms the what we refer to as King's Court or the Curia Regis. So, it was developed in that court. Why the Court of the King's Bench, which was also formerly known as the Court of the King before the king himself was established, was an English court of common law in England or in the English system. The process of the court helps to develop the customs that are common to the English people. And then by the 13th century or thereabout, that a royal council of the King's Court was formed. And then that gave birth to, of course, all of this can still be seen as the origin of the King's Court. But the point we are making is that the common law was developed by the King's Bench, the Court of Common Pleas, and the Court of Exchequer. And the Court of Exchequer was more like the appellate court in this system. Just like we have the High Court in Nigeria, we have the Court of Appeal, and then we have the Supreme Court in order of hierarchy. So the Court of Exchequer was the appellate court for the common law civil action. And then by the reform of the Judicature Act of 1873 and 1875, these processes were, fully recognized, and they became like a system that could keep record of its proceedings, or that could, begin to form like a foundation for what, is to come on it. So the Court of Exchequer, which happens to be the appellate court then, the King's Bench, and all of that were the places where the common law originated from. And one thing we need to know is that law develops with time. And that's why we have to mention those courts that we have mentioned, because sometimes a decision may be reached at the King's Bench and becomes a rule when it goes to appeal, it may be varied, and that variation becomes a rule. And when it also goes on and on like that, it begins to form different rules and regulations as handed down by the court. Now,
question, sir.
Yes, go ahead.
Yeah, please. I understand the High Court, Appeal Court, and Supreme Court for hierarchy of court in Nigeria. But for this common law, can you please repeat it again? I know El Chekau, then King's Bench. What's the last one, please?
Is it Courts of Common Pleas?
Court of Common Pleas. Okay.
Yes, Courts of Common Pleas. Pleas as in P-L-E-A-S.
Okay.
Okay, so those are the hierarchy of court as at then, but all of it forms the common law court. Now, under the rule of common law as a class of law, the rules seem to be that a plaintiff had no cause of action unless it comes within the scope of an existing writ. Now, what do we mean by that? In this court system, before you can bring an action, your action must align with an existing writ that has been created by the court by virtue of the decision that they have reached. And then, if the action you have does not fit into an existing writ, there's no remedy for the individual. Meaning that for you to be able to approach the court must have an existing case that is similar to you, to the one you have. Just to make it, very simple. Where the court does not have, that, if you have a case, you are unable to present it before this system of law. And then something you begin to wonder that, oh, so how will individuals in the common law realm have remedy to the various issues that they may have? But of course, that was the rule of common law, that you must have an existing writ. Your claim must come within an existing writ. And if it doesn't come within the existing writ, you cannot bring a case. And then even if you find a writ that fits your, you will not be able to get effective remedy at common law because of its mechanical application. What we mean by that is that common law system is strict. It follows its rules. So even when you have an existing writ that your case can sit in, you are not also sure that you are going to get justice or going to get remedy because of the nature of this class of law. That gives us another very important features of the common law. And we say that the common law is very strict. It is formal and full of legalism, meaning that if you do not have your claim falling within an existing writ, or if even when it falls within, you are not sure because you're not sure you're going to get justice or remedy because of the other rules that have been listed by the court, which must be followed strictly. So therefore, common law was rigid and defective in a number of ways. One can say that, so how did they come about the writs that they had that constituted the existing writs? Was it not through cases that were brought that those rules were developed? How come can it be said that now you can no longer have any but those that have been established before your case was presented? These are the major issues with the common law system. And also, majorly, we will say that the common law system is very strict. It does not give any form of room for flexibility, unlike other system of law that we may see in the course of this lecture. So, for instance, common law adheres strictly to privity of contracts and did not recognize the concept of trust. Common law recognizes privity of contracts. I'm sure those of you, practically all of you are in 200 level. You have started offering the law of contract, and then in it, you come across this concept with time. Now, the privity of contracts simply explain is that the law only recognizes party to a particular transaction. That it is only when you are a party to that transaction that you can probably bring a claim, or that you can probably enforce a right, or that you can probably demand an obligation to be performed towards you. But it is not always so in the real sense of it. Take, for example, my father has bought a piece of land on my behalf. He executed the deed of assignment between himself and the vendor. And then today, my father is not around, and I want to lay claim to that land. Common law will say, because I was not part of that transaction ab initio, I am unable to lay claim on it, even though that property was purchased for me on my behalf and for my sole use. So that's one of the major issues with the common law. It follows its rule without any desire to bend. Then also, common law relies solely on documentary evidence. Common law relies solely on documentary evidence and had no means of eliciting the truth from oral evidence that the parties to a suit present in court. In the time and era that we are in, where equity seems to be the savior of man, a document can appear to be genuine, and in itself is not genuine because fraud has taken place. But equity may allow some form of oral evidence to query the authenticity of such documents. But unfortunately, the common law system does not in any way recognize such a position. It's just its rule, and its rule alone. Now, Eniola is raising her hand. You have a question?
Yes, good morning, sir. The last point you just said, I didn't get it.
Okay. What I said is that common law, as one of the major issues with it, is that it recognizes documentary evidence solely and does not believe in eliciting the truth through oral evidence. Now, one of the things you will notice in practice is that in the course of a witness being cross-examined, the truth of the matter which he may have concealed may surface. And that's why, as we will see later, equity as a class of law seeks justice. It's not based on technicality like the common law of England. Now, you may have heard of a particular case of Savannah Bank and Agilo. This is a company law locus classicus, that is one of the very notable cases used in explaining mortgages or even issues of the requirement of law as it relates to some certain action. Okay, no, it's actually land law. It's actually land law. Now, in that case, so Agilo approached Savannah Bank for a loan, and it was granted. But the law of the land required that when there is a mortgage transaction, that the parties must seek the governor's consent on that transaction in order for it to be valid. This man obtained the loan, and when it was time to repay, he was unable to repay the loan. And Savannah Bank went to court to exercise, to have power to exercise power of sale over the security that Mr. Agilo presented as a collateral. No, it was even Agilo who went to court to prevent them from executing or laying claim to his collateral. And the court said that if your mortgage, this transaction must be valid, the parties ought to have obtained governor's consent. And Agilo was of the view that since Savannah Bank did not obtain the governor's consent, so therefore the transaction is valid, meaning that they are taking the bank's money. You want to take bank's money, use it for his business without paying back. But of course, the court held that that is the rule, that the document ought to have been perfected to obtain governor's consent. That is an example of common law. They said it's a strict rule. I think section 22 of the land users or thereabout is what covers that area. But can that be a right thing to be done when the man has collected the loan and is now looking for loopholes, legal loopholes, why he should not repay the loan? Of course, the court gave him judgment, but Savannah Bank went on appeal, and the court reasoned it in another way. Yes, the law says that governor's consent must be obtained, but whose duty is it for the court to obtain the governor's consent? And the higher courts discover or unravel or disclose that it is not even the duty of Savannah Bank, but that of Agilo to seek governor's consent on that transaction. And the court was of the view that he cannot benefit from his own wrong. But if we were to be under common law would have said, since neither of the parties obtained governor's consent, then the transaction is valid. But in this case, he went on appeal, and I'm sure the rule of equity was applied, and the court said, no, you cannot benefit from your own fraud. And then, of course, you hear Latin maxims like est topi causa non oricho acho. That is, a man should not benefit from his own wrong, or the court itself should not be used to enforce illegality, because the man wanted to hide under a strict rule, which can be likened to what was obtainable under the common law system. So, generally speaking, the common law is from the English people, and in all its characteristics, it follows the rules developed by the King's Bench, the Court of Common Pleas, and the Court of Exchequer, where this particular law was majorly practiced, and then exhibited a lot of deficiencies like those that were mentioned in this class, and then to summarily say that it was a rigid system of law that gave no room for any form of deviation from rules in order for justice to be achieved. Having said that, we will consider civil law side by side with common law that we have looked at. Remember, we are looking at common law and civil law. So we will now look at civil law.
Question.
Yes, please.
Sir, please, I did not get the hierarchy of the King's Bench, of the Court of Exchequer, and the Court of Common Pleas. I did not get the hierarchy of the court.
Okay.
And how they really.
I did explain that, or I did mention that we have the King's Bench,
King's Court.
the King's Bench, followed by the Court of Common Pleas, pleas as in P-L-E-A-S, and Court of Exchequer. The Court of Exchequer was the appellate court for the other two courts that we mentioned. Somebody actually asked that question. If you were following, I'm sure you will have been able to also get it. So let's quickly move on to look at civil law side by side with the common law that we have looked at. Now, civil law, by way of explanation, is the whole of private law and public law except criminal law. I'll repeat that again, that civil law as a class of law is the whole of private law and public law except criminal law. Meaning that a law will mean civil law when it accommodates private law, public law, except criminal law. Because with time, we will also look at criminal law and civil law as a class of law. And then you recall that I did say that one of the major purposes of this classification is to identify these various features and to also know how they relate or they overlap. So generally, all the laws, excluding criminal law, military law, and martial or emergency law, are the laws that we call or we classify as civil law. And basically, civil law deals with rules for dealing with rights and duties between individuals. Civil law deals with rights and duties between individuals. It is a class of law that is concerned with disputes between citizens. Okay, manages dispute between citizens, and in order to enable parties or citizens to enforce their rights within the society, apart from enforcing their rights, to also seek redress where a grievance has occurred or to seek recovery of their properties when one has been taken away from them. So civil law as a class of law deals with all of this. Helps to enforce citizens' rights, redress a grievance, or recover property for their benefit, and so on and so forth. One good example of the civil law is municipal law or law of a state. Okay? What we call municipal law or a law of a state. Basically, they deal with issues pertaining to citizens, their rights, even the obligation they have to perform towards the states. So, civil law defines rights and duties of persons one to another. This is what this class of law stands for. It defines the rights and duties of persons one to another. Also, civil law is a system of law that deals with private relations between members of a society and can also, like I said earlier, help to provide remedies that may be sought in a dispute. For example, someone has sold his piece of land, and then someone wanted to sell his piece of land, and then a man approached him and said, I want to buy this piece of land. And then, oh, I'm willing to sell. Pay X amount of money, without knowing that the same person who is claiming to sell, wanting to sell the property to him, already sold the property to another person. Meaning that it does not have anything to transfer to the new person. But unfortunately, he has collected his money and disappeared into thin air. Now, civil law can look at issues like this, how this man can recover his money, and even damages where it is practicable. So common law entails a system whereby an individual who is injured by a wrongful act of another can be compensated for the damage which they have suffered. Okay? That is one major thing that civil law stands for. It entails that system where anybody who is injured by the act of any individual, he can seek redress in the court. What are the examples of this civil law? Again, we talk about law of contracts, law of torts, land law, family law. All of these are examples of laws that falls under the civil law as a class of law. So those are examples. And then why civil wrong leads to recovery of money or enforcement of rights. Other aspects of law may deal with other things altogether. But the good thing is that the civil law helps to manage individual relationship. Now, before I take question on that, I would like to say that A.O. Sonny said that the word civil law has several meanings. That is his own view. The Prof said that civil law has several meanings. it may mean the law that is not criminal. This is the way he looked at it. Meaning that the point that we have made earlier still remains valid and can also be enriched by the view of A.O. Sonny. He went further to say that it may also mean the law of a state as opposed to other sorts of law like the international law, or it may mean common law also. So, to those in the armed forces, civil generally means everything which is not part peculiar or part of the military. And that's why the civil court will handle civil matters, while the military court or the court martial deals with issues that pertains to the military. Okay? So this simply is what the civil law is all about. So when we are classifying common law, we can indeed say that common law is even civil law. And that's one of the reasons why we pair them together under this heading, to look at what they mean, how they relate, how they overlap, and distinction, if any. Okay, so that is common law and civil law for you. Now, somebody was raising his or her hand at a time. Are you still willing to talk, or your question has been answered? Okay, Taiwo, please can you speak to us?
Good afternoon, sir.
Good
Please, I
afternoon.
don't understand. Okay, good morning, sir. I don't understand the relation between common law and civil law. Please, can you go over it? Thank you, sir.
Civil law deals with enforcing rights of individuals within the society. Where there is grievance, it can provide remedy. And it is the kind of law that does not involve crime. So what is the relationship between civil law and common law? Civil law, common law was practiced mainly as civil law, meaning that it deals with civil matters mostly or mainly, and for the need of the society or every member of the society to address their grievances, provide remedies where there is need, but it does not apportion punishment like the other classes of law we do. Okay, that's just the link. Collins.
Good morning, sir.
Good morning.
I didn't get the part you were talking about when you were explaining the military as it concerns the civil law. I didn't get that part, sir.
Yeah, so I said, as when you put civil law together, or civil court deals with civil matters. And we gave examples of areas of law that relate to this. We said contract, family law, law of tort, land law, and all of that. They are purely civil. But unlike the court martial, that is the military court, that majorly deals on criminal cases because of the way it's set up or what purpose it is set up for. Okay? I believe I've been able to answer that.
Yes, ma'am. My question is, you said something about the Judicature Act of 1875. I didn't get what you said. What did this act actually do?
You said what?
I said you mentioned something about the Judicature Act of 1875. I didn't get what you said.
Yes, I was talking about the development of the common law courts, which entails the King's Bench, the Court of Common Pleas, and the Court of Health Checker. And I said that the Judicature Act of 1873 to 1875 brought a kind of reform into the system. Okay? Brought a kind of reform into the system. And those were the things that led to the having those courts to be courts of records that keeps the record of their doings, which of course gives room for the decisions of court that may have been taken in such courts or cases to become applicable to other cases or causes that may come afterward. So that's why we mentioned the Judicature Act. Now we move to the second group. What we have just looked at now is the common law and the civil law. We want to look at common law and equity. Common law and equity. Now, as a foundation to this number 2 class, we need to take our mind or refresh our minds on all that we have said about common law, because that also still applies to this second classification. But the aspect we will look at is equity. How common law transited, or how there was a shift from the system of common law and to equity, or how equity came into existence. Now, maybe I should just call on someone to give us a summary of all we said about the common law, so that at least if that comes from you, it will help prepare our mind to look at equity as a side to common law, and to also understand their features and similarities. Anyone? Can you hear me?
Yes, sir.
Okay. So who is giving us the summary? No one? All right. So, of course, we have done justice to that. So let's talk about equity. Is it Chantel or Chantal? Go ahead.
Good morning, sir. So basically,
Good morning.
you said common laws are rules based on the immemorial custom of the English people enforced by the Old Common Law Court of England. And it has an origin from the King's Bench. Then there's like a hierarchical system, Court of Exchequer, Court of Chancery, Court of Common Pleas. Then you move to the features of common law. You said common law is rigid. Then common law recognizes privity of contracts, which means the law only recognizes parties to a particular transaction. It recognizes documentary evidence solely. Then you move to civil law. And then you said civil law means when civil law is a law.
Hello,
that
Chantel, are you
accommodates-
there?
Yes, sir. Hello, sir. Can you hear me? Hello? Hello?
Hi.
Can you guys hear me?
Yes, we can.
Yes, we can.
Oh, so I think it's his network. Mr.
Can anybody hear me?
Yes, sir, we can.
Yes, sir, we can.
Yes, sir.
I think there was a network glitch or something. So, Chantel, can you go ahead or you are done?
So you said civil law accommodates private law, public law accepts criminal law, and civil law deals with the rights and the duties of individuals in the society. It manages disputes between citizens to enable citizens enforce their rights and to also seek readdress where a grievance has occurred. Then you gave like examples of laws under civil law. You said law of contracts, law of torts, law of land, family law. Then you said on like the courts martial that deals with criminal cases, and that's where I'll stop.
All right. Thank you very much. That was a good one. I think it's sufficient for all at the same time. So we move on to now look at equity, common law and equity. Now, the major takeaway from the concept of common law is how rigid the system was. The strict adherence to rules of the common law created a lot of injustice. And that's why we kept saying that, oh, so it means that if you do not have an existing writ that your matter falls in, you do not have a day in court. So it's like more like seeking for an impossibility in such cases. And then one is forced to ask that, is that a good system of law? So by reason of these difficulties experienced by litigants at the common law, situations led to the introduction of equity as a class of law. So on that premise, we begin that the involvement of the class of law known as equity was as a result of the strict compliance with the writ system created by the common law system, which brought about lots of injustice and harm to the people. And then what the whole situation resulted to was that the people or plaintiffs could not get remedy because their issues could not fall into already formulated writs. And then, because of that, they started seeking other ways to get justice. If the courts cannot help, then let's see how we can have a solution to the problem we have. And then people started sending petitions to the king for him to use his good office, as you will say, in our local parlance to rescue them from the hardship that common law has introduced into the system. Started writing to the king, and these petitions became so many. But in treating these petitions was how this class of law known as equity came into existence. And you can trust, just like some of the things we experience here, when you have a need, maybe the result has just been released, and then you feel that, oh, why should I have a B? I read for A, and then I am seeing B. Then you write to the department. And let's say after writing, the department decided to review the grade and said, okay, yeah, this student should actually get a B. I mean A, and the A was awarded. What will follow is that many other similar petitions will come, even from those who had written nothing. But they'll come forward because one of them succeeded in getting an attention. And that can be likened to what happened in the time that common law was in reign. People began to petition the king, "Hey, Max, please use the power of your office to do justice." And then thereafter, equity as a court system or as a class of law was introduced in order to ameliorate the form of hardship that was in vogue under the common law system. And then that led to the Court of Chancery. These petitions that were sent to the kings were handled by people we call the chancellors, who are clerics. These people, because of their nature, they are seen as the keeper of the king's conscience. That whatever the king will do, these chancellors will do, because they believe that they are holy people, they are fair people who will look at a case on its merit and make effort to achieve justice, not technical justice anyway. So what happened thereafter was that based on this petition, the chancellor started granting redress on behalf of the king or the royal council on the basis of what his conscience deemed right in the circumstance. The chancellor will look at the case. Whatever his conscience tells him, that is what he will do. Just like when you go to the normal court system we have today. A judge is not bound to give the same ruling with another judge in the same matter, the same fact, the same parties. They are guided by their minds. So this was the case with the Court of Chancery, where the chancellors sat to address to the many petitions that were sent to the king. And like I said, this whole arrangement was later institutionalized into what is now known as the Court of Chancery. And at that point, the principles formalized in that particular court is what is known as equity. what was formalized or the principles that the chancellors used in managing those petitions were the things that were later formalized and now known as equity. Now, to simplify it, I gave a position or an analogy when I was teaching earlier that my father bought a plot of land for me, and then the deed of assignment was in his name and the vendor. Even though his intention is for me to have ownership of the property, and then when my dad was not around, I made effort to lay claim to it, and the vendor is saying, no, you cannot, because the contract was between me and your father. The chancellor will look at it that, what is the difference between him and his father? The intention of the father ab initio was that this property should be for the son. So therefore, there's no justification why he should be denied of the ownership that was initially vested in his father, who happened to be someone who was acting on his behalf. So this was how equity was developed. And that's why the course that is being offered in the university today is titled The Principles of Equity. So, as submitted, the hardship of that the common law introduced led to all of this. And then the chancellors stood in for the king, helped the king to manage all these petitions, and then they started giving their decision based on how they feel in such matters. And equity is not static. The decisions varies based on the conscience of each of the chancellors. And then what that one led to, like we have said, the principle developed by the chancellors is what became equity. And then the issues were formally, the system was formalized, and then it began to exist as a court, just like the common law. Then if we look at the word equity, which is the summary of the principles developed by the chancery, we say that equity means fairness. What is just? Well, what is natural justice? What is morally right and good? And that's why if you take your mind back to the analogy I gave, you will agree that if indeed that property is even my father's property, not even bought in my name, I should be able to lay claim to it when it's not around or it's no more. So the further development that took place thereafter was that the common law and equity as a system of law applies side by side under the English law, meaning that common law was not did not go into extinction, or it was not abolished. Both the common law and equity worked side by side. Why equity enforced those rights that were not recognized as common law, Then common law maintain its direct rules and regulation. Why common law will not allow oral evidence to buttress or to expatiate or to bring out the justice of the matter, equity allows that to happen. And then by the Judicature Acts of 1873 and 1875, common law courts and court of chancery were merged into a single court. And they had a task to administer both common law rules and equity, or what we call doctrines of equity. By so doing, being a single court, if a plaintiff approaches the court and his case does not fit into an existing writ, equity steps in to create a writ for him. Where a case is at common law and there is documentary evidence that the common law solely relies on, and there is need for the individual to provide oral evidence, equity steps in to allow justice to be done. So, by the Judicature Act of 1873 and 1875, both systems were merged into the system. Now, when you look at Nigeria, the same court is also administering both the rules of common law and the doctrine of equity. We have that here. So gone are the days when we have the King's Court and the Court of Chancery operating separately. They now operate together. And that's why the court of our land, as it stands, does not follow rules strictly, because rules can be used to perpetrate fraud. As we saw in the case of Savannah Bank and Agilo. Agilo wanted to use the rule, the law, to rob Savannah Bank. But of course, equity stepped in to say, no, you cannot eat your cake and have it. You have collected this money. You ordinarily have a duty to repay the money. So whether the governor's consent was obtained or not, you cannot escape the liability to pay. But to put an end to all of this, where the common law and equity sit side by side, when there is conflict between the two systems on the same matter, the doctrine of equity prevailed. Meaning that when there is contention on an issue between the two classes of law, equity prevails, because equity is seen as the system that does not only focus on technicalities, but also is interested in substantial justice. Not on technicality, but must be sure that the person who is getting justice truly deserves what is getting. So that is the end of the lecture on common law and equity. So I'll open the floor for your questions, and then we will begin to bring the class to a close. Now, I will open the chat box for you to be able to send in your attendance while we entertain the questions that may be asked in the course of the class. Yes, the floor is open.
Question, sir.
Yes, please.
Under the comma, we have a case scenario to bring out the equity and the common law. Under the comma, the directors of a company incorporated, we have directors and shareholders. And then they create, there was a creation of an asset, okay? And then the directors were nominated. and they didn't even pay for those shares, right? But the person that actually gave them those shares, right, now came later to say that, look, I am the owner of this asset and I want to reclaim back my assets. Of course, the law of karma says that, from little I think I know, that the shareholders and the directors are the owner of the assets of the company, but knowing fully well that they are not the owners of those assets. But what's the place of equity under this karma when they are in court and the owner of the asset is asking for his asset, knowing fully well they are not the owner of the asset? So can it prevail over the law of karma?
That is the position that we have established here. The rule as provided by karma, there are strict rules that require strict compliance. And that's why you kept referring to the position of the law as contained in karma. But the court of the land is saddled with the responsibility to do justice. The case of Solomon, I think that's where your reference appears to be. That's like the fact of that case.
Yeah, I think there's even another case study of Saraki, and I think of his friend. I think there's an authority on that as well. But I just need clarification. Yeah.
Yes, the point I'm making simply is that the court of law is saddled with the responsibility to look into those issues, and where the law is to be engaged to commit fraud. Court of law in Nigeria or court of equity will not enforce that law, because the end point of law should be justice, and not that it will help to perpetrate fraud. The court, the community, the society is against fraud. So why should its law help to enforce or to perpetrate fraud? Those may have, happened, and then there is a success under common law, but not when equity has been merged together, and it has a duty to ensure that justice is done.
Thank you, sir. I'm clear.
You're welcome. Any other question? Okay. So in the absence of any other question, we'll call it a day. And by God's grace, tomorrow we'll meet. Please enjoy the rest of your day. God bless you.
Bye, sir.
Thank you, sir.
Bye.
Thank you, sir.
Thank you, sir. Ìfẹ́ Olúwadòsùnmú, how are you doing?
Yeah, I'm fine.